Welcome to Denver Startup Week. I'm Ben Data, co-chair of DSW. This year marks the 10-year anniversary of Denver Startup Week. This community has been the catalyst for lots of change over the past decade, and this week we're coming together to celebrate the past and dream big for the future. We are able to bring Denver Startup Week to this community thanks to our 2021 sponsors. Thank you to our HQ and title sponsor, Amazon, and our title sponsors, whose leadership makes this week come to life. Capital One Cafe, Downtown Denver Partnership, Fluid Truck, Hotel Engine, and WeWork. And our track sponsors, who have made all of the great content you're hearing today possible. Founder Track, Kickstart, Growth Track, Friday Health Plans, Developer Track, Quizlet, Product Track, Palantir, Designer Track, Battery 621 in the Public Works, People Track, Exactly, and Spotlight event sponsor, Strat Labs. Our headline event sponsors are bringing the excitement this week. Thank you to B-Side Fun, Colorado Public Radio, Comcast, Coors Brewing Company, Denver Pavilions, Entrepreneurship at the University of Denver, Gusto, JP Morgan Chase, Method, Moss Adams, Pine Insurance, Promontory Mortgage Path, Red Bull Basement, Southwest, Tattered Cover, and VF Venture Foundry. Finally, thank you to our partner and member sponsors listed on the screen. Please say thank you to these companies as you enjoy our hybrid Denver Startup Week. And don't forget to use hashtag #DenStartupWeek to share your experience and moments of inspiration on social media. Have a great week.
The Public Works is a Denver, Colorado-based design, fabrication, and multimedia marketing firm that allows your company to craft an authentic presence to your target audience. For the past 15 years, the Public Works media team has been telling stories with words, pictures, and films. Our unique approach to brand storytelling allows us to get strong reactions and results from our content. We work in experienced and nimble teams with our crew of producers, directors, and cinematographers that all have first-hand experience and international presence. We are fortunate to have amazing clients that allow us to get wherever we need to go with the right tools for the highest production value. Lots of people can take a pretty picture. Just look at Instagram. While we believe our images speak for themselves, what really sets us apart is our decades of experience, our network, and our ability to make shit happen when it counts. We love bringing unexpected partners together to create added value for everyone, and most of all, we love when we finish a job confident that we've not only executed, but elevated the end product, and we know that everyone involved enjoyed the process. Our company was founded on the idea that life is about learning and teaching through every experience. We apply a strict discipline of work hard, play hard, and make great fucking work. We amplify awesome. We surround ourselves with the best and feed off of infectious innovation, ideas, collaboration, and building long-term friendships and partnerships. Contact us anytime for a meeting at our office, golf course, or on the chairlift.
Hi everyone, welcome to Denver Startup Week. I'm Castle, the Designer Track Chair and member of the Denver Startup Week Organizing Committee. Thank you for joining us for the 10th anniversary of Denver Startup Week. At Denver Startup Week, we strive to make all of our sessions a space where attendees can connect, learn, and grow, regardless of age, gender identity, gender expression, race, ability, or sexual orientation. A special thank you to our sponsors for their support in helping us keep DSW free and accessible for all, especially our Designer Track sponsor, Battery 621, and the Public Works. Thank you for joining us and have a great week.
Hi, should we get started, Castle?
Hi, I was trying to show myself, but I don't know. Maybe I don't need to.
We can see you.
You can see me. I don't know if the guests can, but anyway, welcome to 10th anniversary of Denver Startup Week. I've been here all 10 years. And it's great to be here with Meredith and Dave with CBCA. For those of you that don't know, CBCA is a great resource in Denver for creatives. Colorado Business Committee for the Arts. They have a lot of great programs and information sessions throughout the year. So definitely check them out. And I'm really excited that they're presenting on this topic because I think we've all been there before. Can I post this, or how do I post it legally and give credit and not get in trouble? What else? Hashtag done startup week. Share the information. Everything we're filming and all these Zooms are going to be broadcast live, but also on YouTube, so you can share and watch them later. Be sure to visit the downtown Denver Amazon headquarters and go upstairs because we have a really cool art installation, speaking of art. And be sure to visit the Denver Startup Week About Last Night designer track after party every night at the Block Distilling Co. I think that's it. So take it away. Thanks so much, Meredith and Dave.
Awesome, thank you. Well, I have a few intro things while I let Dave go ahead and share his screen. He'll be leading us through the presentation. But in the meantime, here we go. I'm Meredith Badler. I'm the Deputy Director at CBCA, which is the Colorado Business Committee for the Arts. As Castle said, thank you. You got it right. We do a lot of things at CBCA, all about connecting arts and business to advance our creative economy. You as entrepreneurs, as people who are interested in the designer track, you are part of that creative economy. And so we're so excited to connect with you today. While I talk a little bit about one of the programs that sort of brings us here today and how Dave and I get to work together, I'm going to invite you to find your chat feature. I know some people already have, and introduce yourself. This conversation will be much richer, more fruitful if we being Dave, know who you are, what kind of creative work you do, what's your business, what brought you in general to this conversation today. Throw that in the chat. I encourage you to chat it to everyone so we can all see who's with us today. We have a great group. So I'll let folks do that. So say hello, let us know who you are. And one of the things, as I mentioned, that we do at CBCA is run a program called Colorado Attorneys for the Arts. Dave Ratner with the Creative Law Network is one of those attorneys. There are literally dozens and dozens of them that volunteer with this program. And Colorado Attorneys for the Arts, or CAFTA, as we call it, is a legal referral service that connects creatives of all kinds, artists, performers, designers, creative entrepreneurs, and so on, with pro bono legal services. If you don't know, pro bono means free. So there's a pretty thorough application and vetting and matching process, but we've been doing this for just about 6 years now, connecting artists and creatives with free legal help for legal matters directly tied to their creative work. So that could be questions about copyright registration or copyright enforcement, trademark, contracts, drafting contracts, reviewing contracts, negotiating contracts, landlord-tenant issues, employment issues, business formation issues, a whole host of legal matters fall into that. It just has to be connected to your creative work. You can be anywhere in Colorado, which is pretty awesome. And then we also provide legal education, training, resources, webinars, articles, things like this, all over the place, all the time. Dave and I were just in Steamboat last week giving a talk like this. We really love it. And then I threw on this slide to an opportunity we have coming up at the end of October. So hopefully you'll have a chance to ask some questions here, but if other questions come up, we are hosting a virtual legal clinic for, again, artists and creatives of all kinds to ask questions. to have a 20-minute conversation one-on-one with one of our attorneys. That is entirely free. Registration is open now on our website. I'll throw some links in the chat too. And great, I've seen some folks introduce themselves. We have some graphic designers, marketers, lots of good stuff. More graphic design. We get a lot of that here at Startup Week. We love it. And today's content is very relevant for that. So Dave, go ahead and go to the next slide there. So that's what we'll be talking about. Can I post this? Should I post this? How do I post this? Do I post my work, your work, their work? Everything in that realm, that is what we're here to talk about today. We hope you ask a lot of questions. And with that, I will turn it over to Dave Ratner with the Creative Law Network to introduce himself and lead us through the content today. Thanks.
Thank you, Meredith. Awesome. I appreciate it. And thank you all for being here. Thank you for posting in the chat. Please continue to introduce yourselves. The reason for that is because I am here for you, right? We are giving this presentation for those of you in the room and everybody who gets to watch online afterwards. And this becomes much more interesting if it applies to you and your particular circumstance or situations. So as I go along, please feel free to post questions in the chat. If I happen to miss them, Meredith can poke me and remind me. I have this unfortunate condition with my machine where as soon as I start presenting, I lose my cursor. So I may fumble around a little bit, and I apologize if that happens. I'll give you my background briefly, just so you know where I'm coming from. I'm an attorney. I run a law firm called Creative Law Network. We work with all sorts of creative people and businesses on tons of different legal issues, a lot of them related to intellectual property, which is a lot of what we'll be talking about today. In my former life, I was a band manager. I was a tour manager. I was on the road with bands. I can drive a 43-foot bus, and that all gives me the background to know where we're coming from as creatives, as people in the creative industries, designers and otherwise. And also really gives me this connection to the folks that we work with. Also, I volunteer for Colorado Attorneys for the Arts. So please make sure to check out that service as well, coloradoattorneysforthearts.org. So let's dive into what we're talking about. Can I post this? Can I post things online, specifically creative content? That includes all sorts of copyrighted works. So a few examples here of things we might add to the whether it's our own websites, social media, maybe a YouTube video, anything like that. This all came about, well, last March when everything went online. We suddenly realized, man, everyone's posting, but do we know what we're allowed to post? And so that's really what gave us the impetus to create this this presentation, is so that when we are creating content, whether it's for ourselves or for our clients, we kind of know the rules of the road. So the creative content we're mostly concerned about is copyrighted works. Examples: music, video, 2D images like photographs, paintings, or even pictures where we have other creative works in a 2D image like a sculpture or some fine art. Copyright also protects words that are written or spoken. It protects choreography, all these other things. And each of these things is protected by copyright. So we're concerned, or the reason this is important is because if we are using copyrighted work in our online content, we need to make sure we're allowed to do so. So what is protected by copyright? It protects any original, what we call original work of authorship that is fixed in some way. The copyright law says fixed in a tangible medium of expression, which is a little bit of legalese, but basically means it's some way captured so you can show, yes, I created this. So The 7 things listed here are actually straight out of the Copyright Act. It protects literary works, musical works, dramatic works, pantomimes, what we call PGS, pictorial, graphic, and sculptural works, motion pictures and videos, as well as architecture. So that is in the kind of scope of things we want to be thinking about if we're adding music to our videos, if we're going to put a sculpture in the background or take a photo of a sculpture, we have to be concerned about, is this work copyrighted? And so we'll talk about copyright a lot today because that is the most concerning intellectual property that we might include in our online content. Intellectual property is basically property that we can own and sell and buy and license and transfer, but that we can't touch. And so if we think about it, it's a little sometimes hard to grasp because, for example, if I paint a painting, I own the copyright in that painting. If I sell that physical piece of canvas, I've sold a piece of canvas, I haven't sold the copyright. The copyright is actually intellectual property. So also important to talk about what copyright does not protect, because it does not protect ideas, systems, and facts. So when we say, if I have an idea for a painting, that does not mean there's a copyright. It's only once I paint it or even create a sketch, then it is fixed, then it is protected by copyright. Brenna, I thank you for your question. I will get to the answer to your question. We're going to talk a lot about ownership and rights that we can use. So thank you. And if I don't, well, I promise I'll get there. So just important to recognize that there are certain things that we don't have to worry about being protected. Facts is another one. If we want to post, include in our online content, the date of the US Constitution or some historical fact, fact about some scientific mathematical fact, that cannot be protected. So that is also not something to worry about. Then what we think about when you own a copyright is, well, what does that mean? What does that grant you? What do you get when you own a copyright? So copyright protects a set of exclusive rights. And what that means is the copyright owner is the only person who's allowed to exercise those rights. So using example, again, I painted this painting. I own the copyright in that painting. I am the only person allowed to reproduce it, to prepare derivatives of it, to distribute copies of it, or distribute it, to perform it, not so much with a painting, but to display it, certainly something we do, and perform by digital audio transmission. Again, this is straight out of the Copyright Act. But it is important also, prepare derivative works. That means to create something based on the original. So taking a photograph of my painting would be a derivative of the painting. And certainly this translates, I know we have a number of graphic designers in the room, applies the same if you create a digital image. It doesn't have to be physically tangible, it just has to be fixed. So you create a digital image, you own the copyright, you own this set of exclusive rights, you are the only person allowed to do these things with that copyrighted work. And that becomes important because if someone else does that with your copyrighted work, that would be copyright infringement. So if I create a digital design, a graphic design, someone else goes and makes copies of it or distributes it, these exclusive rights, then that would be an infringement if they're doing that without my permission. Getting to the answer to Brenna's question here, who owns the copyright? So by default, a copyright is owned by the creator. That's why I'm saying if I paint the picture, if I create the design, I own the copyright in that design. And that is the technical term, the legal term we use is the claimant is the owner, and the author being the creator all means the same thing. You create it, you own it. And that also applies if multiple people create a single copyright work. There are multiple owners who all co-own the work. that can become relevant because if multiple people own a work, any one of them can go and use those exclusive rights that I was just talking about. So if Brenna and I collaborate on a painting, we both own the painting, and we can, either one of us can take photographs of it. Either one of us can make copies of it. We just have an obligation to account to the other one. Well, where does this come in if you need to use that painting that Brenna and I created? Well, you can ask either one of us. So that becomes important as well if we're using other people's work in our online content. I'll try today to talk about both posting our own content online and using other people's content that we post. The latter tends to be the more relevant or common issue we run into is, can I post someone else's work? But certainly, please give me your experiences in the chat so I can make sure to customize this to what you're thinking or what you're doing. There's kind of an exception to the rule for copyright ownership. The rule being whoever creates it owns it. The exception being what's known as a work for hire. Really important concept for creators, designers, and those of us making copyrighted works, because if an employee creates a copyrighted work within the scope of their employment, then the employer owns the employee's work. Example being, if you were let's say you do design for a newspaper. Okay, you're doing design for the newspaper, and you create a design. Maybe you're creating a new layout, new logo, something of that nature, and it is your job to do that. The designs that you create are owned by the newspaper. They're owned by your employer. However, if you work for the newspaper and you do delivery, you deliver newspapers and you create a copyrighted work, the newspaper does not own your work because it was not within the scope of your employment. So there's kind of the default that if you're a creator creating for your employer within the scope of your employment, it is a work for hire. We don't need anything in writing. Employee, you're generally, if you're a W-2 employee, you're generally considered employee, which, by the way, is different than independent contractor. An independent contractor is not an employee. They're a W-9 or a 1099, not a W-2. And therefore, what an independent contractor creates for someone they're working for is not a work for hire unless there's a contract that says that it is. So common example I always use with folks, because if you're having a wedding and you hire a photographer, you would think, oh, well, this photographer took all these photos of my wedding. I obviously own them, it's my wedding. But the photographer is an independent contractor. They're not the bride or groom's employee, and therefore it is not a work for hire unless there's a contract between the photographer and the couple that says this is a work for hire, or the rights are transferred over to the couple. So that is where we get into the ownership. The squeaky tiki question, Squeaky, I will also get the answer to this in the context of our conversation. So thank you about where you can post it. We'll talk about that in a little bit. One other thing to talk about as far as baseline copyright is the term of a copyright. The term of copyright is how long the copyright lasts. And in fact, it lasts for a very long time. The term of copyright is currently 70 years after the life of the author. So if I paint a picture today, that copyright exists until 70 years after I pass away. So that copyright continues, gets transferred to my heirs as part of the estate, but it continues to be owned, which is why we may have deceased musicians, fine artists, whoever, but their rights are still protected, or their creations are still protected by copyright. The exception to this is a work for hire. Work for hire lasts either 95 years after first publication or 120 years after creation, whichever expires first. So when something's created as work for hire, it is a different term But it's really important to know how long a copyright lasts, because that affects whether we can post a creative work that we don't own. I would generally say that most things are still going to be protected by copyright, but copyright does expire after a certain amount of time. The tricky thing about the copyright term is that the copyright term has lengthened over time because the law has changed. The Copyright Act has been updated. So something that was created in the 1960s was not under the current Copyright Act. So if something was created in 1960, it doesn't automatically expire in 2030 because that may have changed. And it's changed, the act has changed multiple times. So knowing whether something is still protected by copyright is a bit of an exercise. Something that is not protected by copyright is now in the public domain. So the public domain refers to works that are not protected by copyright, where the copyright has expired. The copyright term, 70 years after the life of the author, is, by the way, the law in the US, not in every country. Every country has their own rules. So what I'm talking about today is limited to US copyrights. So the public domain protects anything that is no longer protected by copyright. This is relevant because if you're interested in using a copyrighted work that is no longer protected by copyright, that is in the public domain, you do not need permission. If something is so old that the copyright has expired, you can use that public domain work without permission. At this point in the US, anything created before 1926 is generally protected by copyright, in the public domain. So that can be a good yardstick. There are things since 1926 that are also in the public domain, depending on what happened with that copyright during its lifetime. Again, this gets into things that are a little bit more technical. This is something our firm does, is to figure out, is something protected by copyright or not? So I think, I want to make sure to answer the questions that we had from Squeaky and Jenny. So the question that was posted is, if I do freelance for a design firm and create a logo design, can I post it to my website portfolio page? This really depends on the agreement between you and your client. And one of the things about being an independent contractor or freelance is to have an agreement for every job that you do, because it will answer these questions and also help in the event there's a dispute about, can I post this? Or what do I get paid? Or when is delivery due? So the answer to whether you can post it depends on the terms of that agreement. In the absence of an agreement, if there is no contract, then yes, you can post it because you own it, right? Whoever creates a work owns that work. In the absence of a contract, you would still own that work. Now, the reason I encourage you to have a contract is because that contract will explain, what can your client do with the work? Can they put it on their website, their business cards? Can they put it on t-shirts or hats? Can they put it on a billboard? I don't know. Can they create derivatives? Can they change it in the future with or without your permission? All of those things should be in that contract. But by default, you created it, you owned it, you own the copyright, so you can reproduce it, create derivatives, perform, display, all those exclusive copyright rights that I was describing before. Jenny asked, if I am both an employee and an independent contractor within the same profession, if I create a very specific document to teach within the company for which I am an employee, can't I just change the document a little when teaching as an independent consultant? So this has to do with the use of a derivative or the creation of a derivative work. What underlies this question is that if you're creating a document for two purposes, you create it for one purpose, can you use it for another? If you create something for a company within the scope of your employment, they would own the copyright, which means they control whether you can make a derivative work or not. So if something is created as an employee within the scope of the employment, You do not have rights to it. It is owned by your employer, and therefore only the employer can create a derivative. Now, these are all kind of general. I certainly am not, I cannot offer any legal advice here because I certainly don't know all the facts just from a small chat, but I can certainly talk in generalities. And in general, something created by an employee within the scope of their employment is owned by the employer, and therefore the employer has the exclusive right to make derivative works. And derivative work would include changing the document and using it for another purpose. Now, remember, we cannot copyright facts, ideas, systems, and there are other rules that are far more technical about whether something can be copyrighted. If it has to have a certain amount of creativity and originality. It has to be substantive, so just a single line of text is not generally enough to be copyrighted. That's why we can copyright a whole poem, but not just the title of a poem. So it really does depend on the document that you are creating. And that is, that would be the default. If you create as an independent contractor first, well, in that case, you would own the copyright. And then you have the right to let your employer use it. So it actually really does matter, not only in the order in which it happens, but also, whether the extent to which that document is protected by copyright. I should mention something that's very relevant to the copyright conversation, which is copyright registration. So whoever creates a work owns the copyright as soon as the work is created. We say as soon as you lift your pen from the paper, you own the copyright. However, in the US, we do have a copyright registration system which allows us to register those copyrights with the US Copyright Office. The purpose of registration, or the function of registration, is to have the legal proof of your ownership. And the other thing that happens when you own a copyright registration is you can then protect the copyright in court. Unfortunately, if somebody infringes your copyright, you often or sometimes need to go to court to enforce those rights, to file an infringement action, and you need to have a registration in order to file that infringement action. So a copyright does not have to be registered in order to exist, but it does need to be registered to be protected in court. So that sometimes factors in to this conversation or to your work as a creator, as a copyright owner. So I will talk for a moment about infringement, which is kind of the negative side, the downside to what we're doing here, in the sense that when we are posting things online, we don't want to commit infringement. We do not want to use someone else's copyright without permission. So that's basically what infringement is using the copyright in one of those ways: reproducing, creating a derivative work, displaying, performing, distributing without permission from the owner. That would be an infringement, and the infringement is a violation of federal copyright law, so something we certainly want to avoid. Infringement penalties can be up to $150,000 per infringing act. So it is certainly not something we want to stumble into. And as a copyright owner, the value of the registration is that we can pursue that infringement. So again, not wanting to think too much about the negatives, but it can be someone who is guilty of infringement can have to pay their profits to the owner, can have to pay $150,000, can be subject to a restraining order, can have, if you are, let's say, making physical prints, those items can be confiscated or destroyed, and you can also have to pay the other side's attorney's fees. So all good reasons to not post things that we don't have the right to post. Now, this doesn't always happen, all of these infringement penalties that I'm scaring you with, but it's incentive for us to play by the rules, only post things we have the right to post, only use copyrighted works that we have the right to use. So as a general rule, I would say that we want to assume that any relatively modern work, relatively recent work, is still protected by copyright. Assume that if it was created in the US in the past 95 years, it's probably still protected by copyright. There is a Copyright Office database. So if you're trying to figure out, well, who owns this copyright, we can look in the Copyright Office database. But remember, the Copyright Office database is only a database of registrations. So if I paint a painting and I don't register the rights in that painting, I still own the copyright, but it will not appear in the Copyright Office database. So the database is a useful tool, but not all-encompassing. Does not cover every copyright under the sun. The best way to get the rights to use a copyright is to contact the copyright owner. The copyright registration will list the contact information for the owner, but otherwise, we may have to do some searching around to try and find that copyright owner before using someone else's rights. I see Brenna said that, I'll just, any of our own art. So Brenna has a question here about, if I post something on Instagram, does that mean anybody can use it? That is not the case. It is that if somebody uses your work and you need to go sue them for infringement, you would still need to have a copyright. You would need to have a copyright registration. Brenna's question was about posting on Instagram. So I will take a moment to talk about social media. So posting images or content on social media follows the same laws and rules that govern all copyrights, but is also governed by the terms of use of that social media company. So taking Instagram as an example, when someone signs up for an Instagram account, they agree to all the terms of service, the contract between the user and Instagram that describes what you can and can't do. Those terms of service are going to say that you can post things, and it'll also say what Instagram can do with those things. As a copyright owner, you will grant Instagram the right to put your photo on their app, on their website, on their service. You're granting them a license. You're allowing them to reproduce the photo, granting a copyright license to Instagram to use it on their service. But that does not mean you've given up ownership. It does not mean anybody else can use it except for reposting. So right-click Save As is not allowed by those terms. It does not allow anybody else to use your work. It only allows Instagram to use your work. And if someone uses your work if someone reproduces your work or uses your work through social media without your permission, or on any website without your permission, you can issue what's called a takedown notice. So we have a federally guided takedown procedure for when copyright works are used on social media or similar websites without permission. This emanates from something called the Digital Millennium Copyright Act, which is a now somewhat outdated law, but still a law that came into being around the turn of the century that was intended to kind of govern the digital space around copyrights. What it provided for was basically to address websites like social media, and actually YouTube ended up being very relevant in the courts regarding this, because these sites that aggregate or allow people to post on their sites, well, they're not responsible, or they say, we are not responsible for what our users post. So there was a lawsuit, basically when YouTube first went online, every movie and television show was getting posted to YouTube. And so the Viacom, which owns CBS and MTV and owns a lot of content, they own a lot of copyrights, they sued YouTube and said, YouTube, you are infringing all of our rights. You are posting all of our stuff. You're reproducing our copyright works without permission. that is infringement. And so we're suing you for billions of dollars for infringement. YouTube said, not our fault. Our users are doing this. And we have a notice and takedown procedure where Viacom, if you see one of your shows on our site, you submit a takedown notice and we will take it down. And the law provides there's 6 things you have to include in your takedown notice and we will take it down. There's also a counter notice procedure that isn't that relevant here, but it is important because if we are posting on any site that allows other users to post, they should have a notice and takedown procedure. They are governed by the Digital Millennium Copyright Act, and they have to take down infringing work if you tell them that someone's infringing your work. So this applies to Instagram and Facebook and YouTube. It will not protect you if I own a website, and so my law firm, Creative Law Network. If you go to creativelawNetwork.com and you see your photo on my website, I put it there. No one's allowed to post on my website except me. So the Digital Millennium Copyright Act does not apply to me because I posted on my own website. So it protects sites that allow other users to post because it provides what's called a safe harbor for those websites like social media, that as long as they take down infringing works, they are protected. They are in that safe harbor. So that is a very long answer to Brenna's question about Instagram. But this is what's most relevant, or rather very relevant, because there is so much interaction on so many different platforms, not just the Facebook, Instagram, WhatsApp, and LinkedIn. Right? There's a lot more out there than that, but this is relevant to that. And it also is important. There's a common misconception that by posting something to a social media site or to any website that you've given up ownership. And that is not the case. The owner of a copyright still owns the copyright. The only way a copyright can be transferred, so the only way ownership can change is in writing, has to be in writing for ownership of a copyright to change hands. So you're never going to lose your copyright unless you've signed something saying you're transferring it. For a lot of us, we find that we don't want to own someone's copyright. We just want to use it, right? We're creating a video. We want to include some imagery or some music. We want to use someone else's copyrights. So the way that we do that is through a license. A license is kind of like renting some rights. So if we compare intellectual property to tangible, real property, if you own a house, you own real property. The only way that can be transferred is in writing, just like a copyright. And but if someone wants to lease your house or rent your house, you can allow them to use it for a certain amount of time, for a certain purpose, etc. And that is what copyright licensing is. It's allowing others to use a copyright under certain circumstances. And that is how we can, if we are creating online content and we want to use someone else's copyrighted material in our online content, we want to get a license to use that other party's copyrighted work in our posting. So let's talk a little bit about licensing. There are 2 main ways that we license copyrighted work. These are either a direct license or a blanket license. Generally, a direct license is, I want to use your work on my website. I go to you, I say, please give me a license for your photo so I can put it on my website. It is a direct person-to-person license. Other option is a blanket license. I want to use a photo from a stock imagery website on mine. So I go to iStock Photo, I go to Pond5, I go to one of these many stock imagery sites, and I get what's called a blanket license for any of their photos. And that allows me to use anything in their catalog for my purposes. In either case, a license should always be in writing. It's very common that people will say to me, well, I've got the rights to use this song because so-and-so said I could do it. Okay, I believe you, but how do we prove that? Now, a non-exclusive license doesn't legally have to be in writing. We can have a handshake deal, but we have no proof of it. So when I'm talking with my clients about how to get a license, we always want to have it in writing. The question I always get is, well, is text good enough? Is an email good enough? It very well may be, but it's not the best because there's a lot of details that have to go into a direct license. So we want any license to be detailed, specific, and explicit. We want to cover and answer a lot of different questions. What is being licensed? What use is allowed? In what formats? In what territories? For how long? For what payment? All these things will need to be included, whether it is in an email or in a contract. We want to make sure all those things are included. It's easy to think, oh, well, we know the deal, right? So-and-so said I can use their music on my website. He knows I can use it forever, or he knows I can use that music with some other images and flash images across the screen, or he knows I'm going to use it to advertise my stuff. But we don't know if that's not in that license, there's no way to know. So we want to be very specific. Can we use the entire song or just a clip of the song? Can we use it with other images? Can we use it to advertise a product? Can we use it in our social media as well as on our website? Is this only allowed in the US or can we do it worldwide? Does it last forever or is it just for a year, a couple of years, a set amount of time? And most importantly, at least what I see is problems, when problems pop up, is for what sort of payment? Because someone may have said, oh yeah, you can use it, but they're expecting something in return. And that could even be credit. Do you have to credit that person on the site or with the use? I frequently see with photographers and designers, they say, well, yes, you can use my images, but you have to, maybe it has to be watermarked on the photo, something like that. So credit can be really important. So we want to make sure that all of those questions are answered in any license agreement, which is why a text generally doesn't answer that question. And it goes back to the earlier question about if I create an image for a client, can I use it in my portfolio? Excuse me, can I use it in my portfolio? Well, if the contract says you can use it in your portfolio, then you can. Or if the client, there's a lot of those kind of permutations of these possibilities. So a direct license is a very common way of getting the rights to post something online. The other way, as I mentioned, is a blanket license. Blanket licenses in this context generally come from online databases like stock photo, video, music websites. And all of those websites will have terms of use, terms of service, licensing terms, something like that. It's generally in small type at the bottom of the screen on that website, but it has to be there. And it is important to review those terms if you're going to use this content on your site or in your post, something like that. Reading those terms will oftentimes answer the question, can I post this? One of the most common things I see with blanket licenses and can I post this is whether it's for a commercial purpose, whether we can do it for business or personal reasons or uses, I should say. So because a lot of these stock websites will have a free version and a paid version. So you get a free membership or a paid membership, something like that. Oftentimes, the free version is for personal use, for non-commercial use only. Oftentimes, to use it for a business purpose, you have to pay for the license. So you want to ensure that your planned use is fitting into the terms and also the kind of level that you have. And not at all uncommon. There are certainly websites out there that will allow commercial use without paying for it, but you want to be sure because we do see a lot of issues arise when we're using it in a way that's not permitted by those terms of use. So that pretty much covers the licensing side of things. I pretty much answered this before, but the idea of does posting grant a license? This again is based on the terms of use for the website or social media service where you're posting the content. So it's important. So when you signed up for your Instagram account, you agreed to their terms of service. You checked a box, clicked OK, something like that. And when you're doing that, when you sign up for an account and you click OK, you're generally agreeing to a contract. These terms of service are a contract. So you have an Instagram account, there's a contract between you and Instagram that includes the licensing terms. So there's a license in that contract. And that license will say Instagram has the right to reproduce and distribute the content that you post for Instagram's purposes. It is not very much fun to read these terms, but I encourage you to do so if this is part of your business, because then you will understand what they can and cannot do with your content. Now, as I mentioned before, posting does not transfer ownership. It does not generally allow others to use your content, but that's all going to be in those terms of service. The terms of service can be lengthy and intimidating. They can be full of a lot of legal mumbo jumbo. But the part that is about what we're talking about today, about what we can or can't do with the content, tends to be fairly specific. And it's not the entire terms of service, it's a section there. So if you do leave this presentation and decide, I'm going to go and read Instagram's terms of service, you can scroll until you find the part that's actually relevant to this conversation. But I know there are a lot of questions about interacting with social media. So please post your questions in the chat. We haven't heard from anybody in a while. And again, I definitely want to make sure that I'm answering your questions. Listening to me just speak off of slides is not nearly as much fun as answering your questions. So please continue to add those to the chat. So I do see, there's something in the Q&A. Let me see if I can see that as well. Explain how links between Instagram and Spotify work. Also, what about memes? Okay, so links between Instagram and Spotify. I'm not entirely clear about that question. So maybe you want to tell me a little bit more about what that link is you're talking about. And memes, it really does depend on, I mean, someone creates a meme, they will have the exclusive right to use that meme, but a lot of people will end up kind of giving up those rights, not enforcing their copyright. And that's relevant here because a lot of times people don't want to enforce their copyrights. They're going to say, I'm not going to go after someone for using my music or using my photo on their site because they decided it's notoriety for them. It's free publicity, which, well, I think for all creators, we know that people think that publicity is payment. Sometimes it is, sometimes it isn't. But if you create a meme, you would be the owner of that meme. However, most memes we see are based on pre-existing copyrighted works. Right? We take a clip of a movie or from an old TV show, and we post something funny in it, and that creates the meme. Well, if we're using a clip from a movie, that movie is protected by copyright, and the owner of that movie has the exclusive right to reproduce and display and distribute that movie. So technically, you're not allowed to do so without permission from the owner. Now, there again, some people will choose not to enforce those rights, and that regularly happens with memes. But by the letter of the law, that's not allowed. There's also a question about the legal area posting your own drawing on social media of a known character like Batman, Mickey Mouse, or Darth Vader, or a parody character like Darth Vader. So this question about characters or parodies, well, those are two different things. there's a whole world of fan fiction and fandom that, again, doesn't follow the letter of the law when it comes to copyright. One of the things about copyright is that there is no copyright police. Nobody is out there enforcing copyrights except for the copyright owner. And for a lot of things where we see fan fiction, we see fandom reusing materials that are protected by copyright, it is because the copyright owner has decided not to enforce those rights, even though the law gives them the right to do so. And that is allowed. I mean, that is up to the owner of whether to do so. So there are certain situations that kind of break the rules of copyright just because we're not enforcing them. And so that those recreations, technically, if we take a Batman protected by copyright, we do our own drawing of Batman, that would be a derivative. Only the owner of the Batman copyright is allowed to do that. So you would need a license, but for practical purposes, it's not likely that's going to get enforced. Now, if you drew a whole Batman cartoon, if you animated a whole movie or a short of Batman, that is also an infringement of the owner's copyright, and they're much more likely to come after you, especially if you start getting attention and you get a lot of views. So that definitely happens. So another question here from Ryan. On social media, are you protected from sending friend requests multiple times to the same person, specifically Instagram and LinkedIn? Well, I mean, copyright doesn't really interact with those sorts of requests. So that is going to be governed by the terms of use for that social media platform. And, oh, I think we're getting some clarification. Spotify is linked to be able to be used for Instagram. So as you post something with that music, I assume Insta and Spotify are covering your terms of use. Okay, so when you're saying the interaction between Instagram and Spotify, we're talking about using music from Spotify in an Instagram post. So yes, that is an interaction between those two sites, has to do with the terms of service on both of those sites. If you were to read Spotify's terms of service, it allows them to use the music posted to Spotify for their purposes. And if they're doing linking with Instagram, then I'm sure that has been added to their terms of use, allowing them to post it that way. So for better or worse, that is what's going to be allowed, and there's not much we can do about it if those are what's in the terms of use. So I want to make sure to talk about fair use. Fair use is, so the whole time today, I've been talking about what you can't do. You can't use someone else's copyright work without permission. Fair use is a way to use someone else's copyright work without permission under very specific circumstances. So it is basically a legal test allowing some unlicensed use of a copyright under those circumstances. I will preface this all by saying fair use is very narrow, but the idea behind it is that certain uses are allowed because they are fair. It comes from uses like commentary, criticism, news reporting, teaching. So if I'm writing a review of a book review, a review of a new book that is out, I'm allowed to reproduce certain sections of the book, not a lot, and only for the purposes of my commentary. I can't reproduce the whole book, but I can use some of it for that purpose. So that use would be considered fair. But I have to caution, a lot of people come to me and they say, oh, well, I'm sure this is fair use. It's got to be fair use. It seems so fair. And there are very specific rules about fair use and what is considered fair. So it is basically a legal test. And what I try or one way to explain how narrow this is that fair use is a defense to infringement. What that means is If I go and use somebody's work without permission and they accuse me of infringement, I can claim fair use. It's not something I go to them and say, haha, I'm fair using this. It is something where it is only a defense. And the reason I mentioned that is because we have to be very careful in relying on fair use. It is a case-by-case analysis that we do under specific circumstances. And I'm going to talk about it so you understand it. But I also I come to this with caution because I see a lot of people misusing fair use, misapplying fair use. And so I want to make sure to exercise a fair amount of caution when I'm talking about it. So the way that we do this analysis is what we call a 4-factor test. So if you're saying, can I go use this? Is it fair use? These are the factors we use to answer that question. Now, keep in mind, the only person who answers this question that matters is a judge, right? The only time fair use really comes into play is when a court says, yes, you have a defense to this infringement. But there are times where we can do an analysis because it is so clearly fair use that we say, yes, that use is okay. So I'll briefly go over these 4 factors so you have a bit of an understanding of how this works. For fair use, the 4-factor test includes the purpose and character of use, the nature of the copyrighted work, the amount and substantiality of the portion taken, and the effect of the use on the marketplace. What does that mean? We'll take the example of taking an excerpt of a book when we are writing an article about that book or writing a review of that book. So the purpose and character of the use. What we're really looking about is our purpose and character different than the copyright owners? Are we using it for a different purpose than the original copyright owner's purpose? We often talk about this as transformative use. So have we transformed the work in some way? Have we taken the text and spoken it and recorded an audio or an audio-visual version of it? That would be a transformative use. We're transforming it because we're using it for commentary, not for its original purpose in the book. So if it is transformative, it is more likely to be a fair use. If it is not transformative, it is more likely to be infringement. It's less likely to be fair use. The second factor is the nature of the copyrighted work. What we're really looking at here is how creative is the copyrighted work, because a more creative work is granted greater protection. This means that an easy example, if it's a book of fiction or of nonfiction. A book of fiction is generally going to have greater protection, so the nature of that work is going to make it less likely to be fair use, whereas a work of nonfiction is going to generally have less protection and it's going to be more likely to be fair use. So the second factor is the nature of the copyright work. The third factor is the amount and substantiality of the portion taken. So how much of the original did we use and how substantial was it? If I take an entire chapter out of the book, that's a substantial amount. If I take a paragraph out of the book, probably not that substantial. So taking an entire chapter is not going to be fair use. Taking a paragraph, much more likely to be fair use. The substantiality is also important. There's a case about this that illustrates this point. There was a book written by President Gerald Ford that he wrote after the end of his presidency. Gerald Ford became president because President Nixon stepped down. And after that happened, Ford pardoned Nixon. So when Ford released his book, there was a book review in, I believe it was Esquire magazine. And really, what people wanted to read Ford's memoir about was, why did he pardon Nixon? That was the biggest thing that people were most interested in before the book came out. That was the talk. And so Esquire, they used a portion of the book. They didn't use the whole chapter, but the portion that they reprinted was his answer to why he pardoned Nixon. So the substantiality of the portion used was significant, even though the amount was insignificant. And for that reason, Esquire was found guilty of infringement because the substantiality was significant. So A lower amount or substantiality is going to be fair use. A greater amount or more substantial is not going to be fair use, is likely to be infringement. And the final factor is the effect of the use upon the market for the original. Going back to that Ford example, people who read the Esquire article got their question answered. They didn't need to go buy Ford's book. So the effect on the market was negative for the owner, and therefore was not likely to be a fair use, or was not a fair use, actually. If you negatively affect the market for the original, it is not likely to be a fair use. If you're not affecting the market for the original, it is more likely to be a fair use. It's very common. I used to get questions from musicians doing mashups or mixtapes saying, well, I'm releasing this mixtape, but I'm not charging for it, so I'm not committing copyright infringement. Well, yes, you're not affecting the market for the original, perhaps, but there's 3 other factors here. So just because something is given away for free does not make it fair use. This 4-factor test means that we look at all 4 factors to figure out, can I post this? Can I use this? And enough of the factors have to weigh in favor of fair use for it to be considered a fair use. So again, it's not an easy thing to rely on. And there are certainly circumstances where somebody comes to me and says, here's how I'm planning on using this copyrighted work. Is that fair? And we look at these 4 factors and we say, all of the factors, or 3 of the 4 factors, clearly weigh in favor of fair use. So I think it's safe to say that is a fair use. Just that the majority of the time, that's not the case. So I'm always hesitant to rely on this in a lot of those circumstances. So that should hopefully cover fair use, and not scary about it too much. But I do specifically want to talk about music, because especially in terms of posting videos, use of music is pretty ubiquitous. It's a common question we get all the time. So I want to make sure to cover this issue specifically. I often say that copyright is complicated, but with music, it's twice as complicated because there are 2 copyrights in every piece of music. There's a copyright in the composition, what we sometimes call the publishing rights, and the composition is the words and music, what's written down, essentially. There's a completely separate copyright in the sound recording, what's called the master. So, by example, if I write a song, I will own the copyright in that composition. The creator of copyright owns it, so I wrote the song, I own the composition copyright. I then hand that music that I just wrote to my friend Meredith, and Meredith goes and records my song. She creates a sound recording of the song. She has created the master, she has created that separate copyright, and she owns the copyright in the sound recording. So we have 1 song, but we have 2 completely separate copyrights. Now, it does get more complicated in that Meredith does have to pay me for the use of this under a certain statute or part of the copyright statute. But the point is that when we are thinking about using music, we want to make sure we're thinking about both copyrights. So when we're talking about using music in a video, the use of that music requires a license. That's pretty obvious. You've all heard me talking about licenses today, so you're not surprised to hear we need a license to use music in our video. But I also said earlier that a direct license has to be very specific. It has to be explicit. It has to address the situation. So when we're licensing music for use in our video, it's a specific type of license. It's called a synchronization license. It's often called a sync license. Well, to get a sync license, if I am going to take Meredith's, or rather, let's say Emma is going to take this song that I wrote and that Meredith recorded, and Emma is going to use it in her video. Well, Emma needs a sync license, but she actually needs 2. She needs a sync license to put my composition in her video. She also needs a sync license to put Meredith's sound recording in her video. So this, again, gets more complicated than we might originally think, because you have to sync both sides. We call both sides of music, both copyrights for that song. And oftentimes, the copyright owner is not the same. The owner of the composition is often, regularly actually, is not the same of the owner of the sound recording. So, and unfortunately, there is not a central clearinghouse where you can just go get a sync license for any song. There are different places you can get them. There are stock music websites, so that blanket license idea will work. But it is can be challenging to get a sync license, and especially for popular music. Sync licenses are expensive. If it is popular or easily recognizable music, it is wildly expensive, hundreds of thousands of dollars. So this is why you'll often see in advertisements, right? Every advertisement on television does not use a song you know. A lot of them just have background music. And if you hear a song that you know, whether it's the Rolling Stones or Taylor Swift or anything that is super popular or very well known, it has been a very high price to pay for that. So again, early in the pandemic, we had a lot of folks posting stuff online, wanting to use recognizable music and coming to us and saying, hey, can I just go buy a license to this Beatles song? And unless you have a few $1 million lying around, chances are you cannot. So this is why stock music websites, for those of us not at that $1 million level, can be very helpful, or hiring someone to write some music, having a contract that says, you created this music and you may own it, but you're granting me a license, you're granting me this sync license and some other necessary rights to use it. So again, answering the question of can I post this when it comes to music, as I said, there are some other licenses involved. And a lot of people have had experience around what we call performance licensing, because there are performing rights organizations that enforce these rights. So basically, when we post music on our website, we are performing that music. Now, it doesn't mean we're actually sitting up there with a guitar and playing the music, but by legal definition, performance of music means that is being played over a speaker or played to the public in some way. So it doesn't have to be a live performance. It is coming over the loudspeaker. I mean, anytime you walk into a bar or restaurant and there is music playing, that is a performance. Anytime you see music on television or in a movie, that is a performance. And similarly, if you put music on your website or in a social media post, that is a performance. So if you put a well-known song or a song you don't own into a YouTube video or into a Facebook video, it very well may get taken down because you're performing, as well as synchronizing, that work without permission. Now, these bars and restaurants and websites will often get performing rights licenses. And these rights come from performing rights organizations. Basically, when someone writes a song and they publish that song, they put it on Spotify, they release an album, they're not going to be able to go to every bar and restaurant and website that wants to use their music and collect a license fee from every bar all over the country. They want their music played in all these places. That's how we get popular. But they can't go out and get licenses from everybody. So they grant their rights to a performing rights organization. And the performing rights organization then goes out to all those restaurants and bars and websites and says, pay us a license and we'll pay all those songwriters. So it is a different sort of blanket license. In the US, there are actually 4 performing rights organizations: ASCAP, BMI, CSAC, and GMR. So if you happen to own a bar or restaurant, you will likely be contacted by these performing rights organizations saying, hey, you're playing music in your establishment, you need a license. And if any of you are in that industry, you've probably experienced this. If you are a songwriter or a musician, you need to know about this. But if you're posting music online, you want to think about this. Now, Facebook and YouTube, they have these licenses from the performing rights organizations. So the performing rights are covered. They do not have sync licenses. That is still a problem. but they do have these performing rights licenses. And the other license that's relevant to music is what's called a mechanical license. A mechanical license is when you are mechanically reproducing a song. So basically, when Meredith goes and records my song, I wrote the song, she creates a sound recording. Her sound recording is mechanically reproducing my composition, my song. So she has gets a mechanical license to use my song and pays me a mechanical licensing fee, a royalty. And this similarly happens with Spotify or with Pandora. It happens with YouTube. All of these services that are programming music and are mechanically reproducing it every time you press play, they're all mechanically reproducing the song. They're all using a mechanical license. They should all be paying mechanical license fees. So while I take a drink, any other questions now that I've talked? I've basically done music law in 15 minutes, which is usually an entire semester. So any questions about that, please post them in the chat. That'd be great. Because I've also talked a little bit about these exceptions, right? YouTube, Facebook has certain exceptions because one of the most common questions I get is, well, why can't I do it? Everybody does it on YouTube. So that may be using a clip from a TV show or a movie. That may be using music in the background of your video. And you say, well, it's on YouTube, and why is that allowed, but I can't do it on my website? Well, the reason is that YouTube has something called the Content ID system. Basically, it is a database of every TV show, movie, and sound recording that's been released by any sort of major studio in any recent times. So anytime you post a video to YouTube, YouTube checks that video against everything in its database, and it looks for a match. If it finds a match, it contacts or it knows what the owner wants YouTube to do with your use. So you post a video that includes, a Taylor Swift song, and YouTube has already said to Taylor Swift, hey, we've got all your music. Do you want us to take it down? Do you want us to leave it up? Or do you want us to leave it up and pay you the royalties? And so when you post that video with that Taylor Swift song, it may get taken down because Taylor Swift has told YouTube, take down any use of my song that I have in the lab. Or it may stay up there and they may just pay Taylor Swift the ad revenue from your video. And that's similar to using a clip of a movie or television show in your video. The Content ID system will flag it and know whether to take it down or leave it up. This is also why, for a lot of us, it is not only easier, but from a copyright and licensing perspective, it makes sense to use an embedded video on our websites than to, an embedded YouTube video on our websites than to embed it ourselves. Because if we put it on YouTube, YouTube has their Content ID system, they've done the licensing, and so everything is covered, and then we just embed that YouTube video in our website, and we are generally covered. There's some kind of caveats to that, but it's a common reason we use YouTube, or sometimes we use Facebook Live because they have licensing for music that we don't want to stream through our website. We want to stream it through Facebook Live. So these are some kind of exceptions to how we can post or use copyright content without permission, whether it's directly from the artist or the copyright owner. There's another exception of a completely different sort, and it's called Creative Commons. Creative Commons is what we call an alternate copyright licensing scheme. In other words, if a person owns a copyright and they want others to be able to use it, they can attach a Creative Commons license to it. So I can paint a painting and post it online and say, this is Creative Commons, which means other people are allowed to use it subject to the Creative Commons license. There are a number of different types of Creative Commons licenses. It's all very clearly explained at creativecommons.org. But basically, I'm going to say you can use it, but you have to give me attribution. Or you can use it and you can create derivatives. Or you can use it, I mean, these are the different types of licenses, but it's a really helpful tool for when we're looking for content that we can post that is not our own. If you were to go do a search, an online search for Creative Commons videos, Creative Commons music, Creative Commons pictures of trees, you will find these items that do have Creative Commons license attached to them and therefore allow you to use them subject to the terms of that Creative Commons license. So it is worth checking out if you're trying to find content that you can post without explicit permission. And the last thing I would say, the last exception I'll talk about is live streams. The reason, and this is live streams of music, because again, music is so prevalent in our videos that I did find, especially when we were in lockdown, we couldn't go see live music, when live musicians couldn't perform. We were doing a lot of live streams, whether for the performer, for charity, whatever. And the interesting thing about that, it relates back to the two copyrights that I talked about, the composition and the sound recording, and the use of those two. So if I grab a guitar and I start playing a Talking Heads song on a live stream, I'm streaming it on Facebook Live and I'm playing a Talking Heads song. Well, I'm not using the Talking Heads sound recording. I'm creating my own. I'm playing my own version. I am using the Talking Heads composition, the underlying rights, but they're not being fixed. If I'm not recording that live stream, if it is only being streamed live, it is not being recorded, then generally that is not a fixation, that is not a use of the copyrighted composition, and therefore is not generally going to cause a problem. So somewhat of a narrow exception, but one that definitely came up a lot when we were getting in the pandemic. What kind of became the genesis of this presentation that we're doing today was a lot of answers to that question. So want to make sure to answer that. So coming towards the end of our time together, please, again, give me some more questions because we have a few more minutes left. But I think that we kind of answered the, using content and whether you can post it. You really want to think about, do I have the rights or can I get the rights? We talk about clearing the content. Clearing the content means we got the rights from somebody. And we want to make sure to clear all the content that we're going to use in our online presence, our online lives, posting on wherever we post these things, make sure that it's cleared content. Question about someone being sued for posting a Miles Davis tattoo that she made. I'm not familiar with this lawsuit. So there have been some issues around tattoos. This is posting a photo of a tattoo. I don't know this lawsuit. I can easily explain it in relation to everything we've been talking about today. Okay, so someone creates a tattoo. They have created a copyrighted work. It is art. It is fixed on someone's arm or wherever. And so therefore it is a copyrighted work. So the owner of that tattoo arguably has the right to reproduce and distribute that work. So if someone takes a photograph of that tattoo and distributes it, they are creating a derivative and they are distributing it. That would be arguably an infringement. Oh, it's a tattoo of the photograph. Yes, then the photographer would be filing the lawsuit. So switch that around. The photographer took a photo, they own that photograph. I use the wedding example. The wedding photographer owns the copyrights in those photographs he takes. So if I'm a wedding photographer, I shoot the most perfect picture of the bride and someone gets there, I will own the copyright in that photograph. Regardless of the bride, I own the copyright. She owns the rights to her image, but I own the copyright. So if someone then takes that photograph and creates a tattoo out of it, they are arguably creating a derivative work of my tattoo and creating a derivative work of my photograph. And as the copyright owner, I'm the only one, I have the exclusive right to create derivatives. So to create a tattoo of my photograph. Someone else does it, they're arguably infringing my rights, and therefore they can be accused of infringement. The other case, if you're for some reason particularly interested in tattoos and copyright infringement, there was a famous case about Mike Tyson and his tattoo. I believe it was related to the Hangover movies, but there's a lot of cases out there. I don't remember them all. Hopefully, I have spawned your interest or continued your interest or increased your interest in copyright protection here. And therefore, you'll go and look this stuff up. There's a question here. Can you briefly talk about photo video rights for capturing people's likenesses? I can briefly talk about this because this could be a very long discussion, but I think it is relevant because certainly as we're creating content, if we're taking videos, because we all can just take them with our phones, do we have the rights? So a person generally has the rights to their image. And so using their image for a commercial purpose would require getting their rights. You can't take a picture of me and go put it on a billboard to sell some product, to sell shirts or hair product. You would need my permission to use those rights. There are different image rights depending, or rather, right is also known as rights of publicity. Rights of publicity may vary based on the notoriety of the person. So my rights to my image are different than Brad Pitt or George Clooney's rights to their images. They have a little bit more value. I'm hoping to become famous through this Startup Week video, but they have much more valuable rights than I do. And then there's a question, do book authors tend to have two licenses like musicians do? There is not, when I write a book, if I write a book or a poem or a chapter, there is just the copyright in the text that I wrote. That's the only copyright. Now, what we can do with that copyright, the licensing of that copyright can vary, because if I write a book, I can grant the publisher the right to publish it in hard copy, but I could grant someone else the right to publish it in digital, or I can grant a book publisher to publish the book, but I'm going to grant someone else the right to create a movie out of it. So these, and again, this goes back to why a license has to be very specific and explicit, because if I just say, oh yeah, go publish my book, did I grant them the right to sequels? Did I grant them the right to create a graphic novel out of it? So it's not that there are two copyrights, there's only one copyright, but there are all those different rights within, or that I own as a copyright owner. So that is how that works. Basically, the answer to this question, can I post this, is yes, if you have the rights, or yes, if you license the rights. Maybe if someone else posted it, reposting on the same service, and yes, if it's public domain, but only maybe if it's fair use. Basically, we ask that you get a license or respect other people's rights, get a license, reference back to this video that will be posted by Denver Startup Week on there, I think YouTube, but certainly check that. But this presentation will live on in the ether, so you can always go back and check it out. I will also make sure you have my information. If you have questions, if you wake up in the middle of the night with a copyright question, please feel free to email me. My email is right here, dave@creativelawnetwork.com. It is always fun for me to answer these questions. Always a pleasure to do this with Denver Startup Week. So thank you all for being part of Startup Week. Thank you all for joining us today. And I hope you have a great rest of your week. I will see if I can stop the share so that someone else can speak up.
Thanks, Dave. Right on time. Excellent questions, everyone. Thanks for engaging. Thank you, Dave, for sharing all this great information. And huge thank you to Denver Startup Week, all of the volunteer organizers and sponsors. It is a tremendous event, and we are thrilled to be a small part of it. Enjoy the rest of the week.